Honorable Justice, we will now reorganize the stage and start with session 1. I would like to ask everyone to stay in your seats. Before we get started, let me inform you about the booklet that you will received. You have actually prepared a special booklet for this conference. It's downloaded on the booklet on your table. You will see the presentation materials and various questions and answers that we are going to deal with in each session. It's mostly in English, but in some part we have also provided Korean translation. So please reference them to further your understanding about the proceedings of today's conference. Now, you could also use this QR code or the link that we have sent you to download the booklet on your devices. Now, I think we are almost ready to start the first session. Therefore, I'd like to ask the panelists as well as the moderator of the first session to join us on the stage. So we will start the first session of this 2024 International IP Court Conference. It will deal with the preferred forum in international IP disputes. The moderator will be Honorable High Court Judge Jaheun of the IP High Court of Korea. Please welcome me with one round of applause. Well, good morning. As introduced, I'm going to moderate this session. Same patent is being registered around the world, so we will have disputes in different countries. And of course, everybody wants to lodge lawsuit in the most favorable court of them. So we are going to look into MPEs and how to integrate patent management, as well as the trend of the forum shopping, and to understand the preferred forum of the related parties and what should be the ideal, the justice proceedings that we need to have. Let me introduce the participants in the order of the seating. First, we have High Court Judge Hyejin of the IP High Court of Korea. Next, from the UPC, we have Judge Rian Kalden, second panel of the Court of Appeal at the United Patent Court of EU. Then from the U.S. side, we have Chief Administrative Law Judge Honorable Clark S. Cheney of the United States International Trade Commission, and then former Chief Judge of the U.S. Court of Appeals, Judge Randall, Rader of the Federal Circuit Principal, and I think the topics that we are going to discuss in this session is in the booklet, so please refer to them. First, we will hear the background presentation from Honor Judge Hyejin Lee, and she has 10 minutes for the presentation. She's going to talk about preferred forum of international disputes. Good morning. As introduced, I'm High Court Judge Hyejin Lee. And I'm going to talk about the forum in the international IP dispute. So I'm going to talk about international and regional integration movements, rising MP litigation, forum shopping and forum selling, preference of resolving dispute in single court, seeking unified conclusion, and lastly, I'll conclude with the need, discussing the need for a new and innovative IP court. Now, first, in terms of the international regional integration movement, in the EU in 2020, they adopted unitary patent system. So you have the unitary patent system covering all the EU, and to solve a united patent related dispute, they actually also established a unified patent court. So it has become a best example of the regional integration. UPC dispute will reduce cost and also allows possibility of inconsistent conflict rulings, avoiding inconsistent ruling of the different jurisdictions. However, there are also disadvantages because if you lose, it could invalid patent registered in multiple European countries. So this shows from 17 to 24 the patent litigation trends involving Korean companies. So as you see, after UPC, the numbers have dropped significantly to 2 or 4. In the next slide, in last June, after the UPC was opened, you will see that total 15 suits involved Korean companies. So it's not as Korean companies have not many laws with the UPC, but as UPC is known more and they recognize its advantages, more disputes will be going from Korean company to UPC. MPC, there are two types. You have the patent assertion entities and non-PEAE. PAE is aggressively pursue patent litigation to gain an advantage, referred to patent trolls. And they have negative impact on the innovation of activities of target firms. But there are also MPs that do not engage in the patent litigations. Now, the rise of the MP litigation actually has the issues of increased litigation costs, and to increase their own interest, they engage in forum shopping. They look for their favorable forum. And recently, a third party invested in the lawsuit and gets the revenue thereof is rising, and its cross-licensing agreement is not possible because MPEs do not produce any product. So there is an argument that it's type of technological innovation, but many academia has pros and cons opinions. Now for universities and individual inventors can be MPE because they do not engage in production. Somebody needs to buy their patent to promote invention and innovation. So only looking at the MP litigation from a negative perspective might not be the only way. Let's look at the patent litigation trends in the U.S. This is statistic based on cases. More than 3,000 cases are being handled in the U.S. and more than 50% seems to be coming from the MP. And what is notable is from 2019, so 2/3 of all the litigation involves MPEs. Now it's about U.S. Litigation involving Korean companies. Every year, about 60 to 80 litigations are being lodged involving Korean companies. Next is about Korean forum shopping and forum selling. The patent infringement occurs simultaneously in multiple countries nowadays. So patent holders choose more favorable and influential courts or jurisdictions, and that has become general trend. Recently, also courts promote favorable procedures to patent holders, encouraging plaintiffs to file lawsuits in their forums, and this is called as a forum selling. So in Korea, you can start litigation in 6 districts court, and in most companies are located in Seoul, and because most of the litigation-related attorneys are in Seoul, they preferably use the Seoul District Court. However, patent lawsuits are dealt with the IP High Court in Korea, so you cannot really do forum shopping in Korea. This slide shows that statistics. The survey result of KIMPA that happened in 2022. KIMPA stands for Korea International Property Association. So you see larger markets are preferred, like US and Germany. And once the market is determined, you have to select which justice division you want to go. You want faster process, low likelihood of patent invalidation, significant damages, and easier access to injunctive relief. For US, they usually go to Texas and Delaware. In Germany, I hear usually go to Düsseldorf. Next is preference for resolving disputes in single court. So in case of Korea, would it be preferred forum? No, because we have small market size, so the impact or benefit from an injunction infringement lawsuit would not be booked. So they go to US or Germany, they file the lawsuit there because the markets are large. This trend has become prominent since Apple versus Samsung Electronics Law 6 that goes back to 2011. So this lawsuit actually was known as smartphone war in the world. It's a very well-known case. So Apple launched lawsuits in the U.S. against Samsung Electronics, and it expanded to 50 lawsuits around the world. But the litigation cost and duration was maybe very long, so they actually settled in 2014. Except U.S. cases, all the other litigations were terminated. And then you had the Supreme Court in 2016. Dispute was settled in 2018. With this, the time, cost, and efforts related to litigation, they want to save it, so they go for single court, and this case actually showed this. After this, we have more lawsuits involving Korean companies. Fifth, it will be seeking unified conclusion. This will be also the latest trend. Davos litigation, you probably know, in 2020, it's actually surprised the whole world. Dr. Tyler said that the Davos, his invention of AI, that argued that it has actually create a patent and applied for patent around the world. And when that was rejected, he filed a lawsuit. So in 2020, Tyler's application was rejected by its High Court, but Austrian Federal Court in 2021 said ITs can be inventors. So accepted Tyler's application. Then in UK and US and Germany, in that order, rejected Tyler's application. And then in the full court of Federal Court of Australia in 2022, overturned lower court decision. Instead, South Korea and Japan court also rejected Tyler's application. So Davos case, of course, there were some difference of opinion, but the court around the world referenced the other cases judgment and showed the reasonable conclusion can be drawn up if uniform conclusion might have been available, in my opinion, if we only used one court. But anyways, let's look at the new innovative IP court and its need. IP, this of course simultaneously worldwide require unified resolution, And then we also need a new dispute resolution mechanism because of the geographic boundary collapsing due to internet, IP, metaverse, etc. And there's a demand for court with large jurisdictions that are neutral and predictable and provide legal certainty. In my opinion, UPC-like new court would also be possible in Asia. Now, in 2020, in November, Asian 10 countries and 5 non-Asian countries signed their treaty for cooperation. So maybe it might be a long way, but there would be a time where we could see the birth of Asian United Intellectual Property Accord. Thank you very much.
Thank you, Judge Lee. And next, I would like to ask Judge Rian Kalden to deliver her speech on the background story of the UPC's establishment and the strength of it. And the presentation time is 9 minutes. Please go ahead.
Thank you so much. So let me first explain a bit why the UPC was set up. So the word European has many meanings, unfortunately. So European patents are granted in the centralized procedure by the European Patent Office. But European here means countries that are party to the European Patent Convention. So a European patent could be validated in one of those 38 contracting member states of this convention. And these countries include all 27 European Union member states and 11 non-European Union. The Unified Patent Court is not a European Union institution. It's a cooperation between 18 countries within the European Union. So I'm sorry about this, it's a bit confusing, but it's good to know as a background. Now, each European patent, once it's granted, only has effect as a national patent in each EPC member state. And as said by Justice Tia Rowe, in most of the cases, a European patent therefore can only be enforced on a state-by-state basis. And as a principle of territoriality, it's the member state of the country where the patent is validated and registered that can deal with the validity issues. And as a complication in the European Union countries that are bound by the Brussels regulation, this also involves cases where an infringement defense is raised. So basically, in Europe, patents are very much national rights and also litigated on a very national basis. Now, for these 18 countries within the European Union that cooperate, they have set up one court that deals with their 18 territories at the same time. And this court can deal with the European patents with unitary effect. And that is a new type of patent that will basically validate your patent at once for all these 18 countries at a lower price. And also European patents can be dealt with by the UPC. Now, during the first 7 years, there is a transitional period during which the UPC has jurisdiction for infringement and validity, but the national courts of these 18 countries have that as well. So there is parallel litigation during this period. And patentees who don't like the system or would like first see how the system works out can opt out from the system. So now we have basically 3 tiers. So with unitary patents, you can only go to the UPC. With European patents that have been opted out, you can only go to the national courts. And for all the other European patents, you can go to both courts. And in case there is conflicting patent cases pending, both before a national court and the UPC, we have the Brussels regulation with lis pendens rules, which basically means the court that is first seized gets to do the case, and the case that was pending at a later stage has to be stayed. There is also another parallel litigation between the UPC invalidity proceedings and the EPO, where the patent is applied for. So if there is still opposition and appeal of this prosecution stage pending, you can already start your litigation before the UPC. Now this has two consequences. Before the EPO, you can ask for accelerated proceedings in the prosecution, and before the UPC, you may request for a stay of proceedings until the EPO has made a decision. But I should say the UPC is not likely to do this very quickly. So far, it has been said that the UPC will do this only if it will not cause a substantial delay. And substantial is not a very long time, because proceedings before the UPC are quick anyway. So what you learn from this is that outside CMS territory, there is not necessarily that much of an impact on proceedings before national courts because of the territoriality. Except maybe that traditionally in Europe there's been much parallel litigation, but certainly not in all countries. So what you see and saw is that litigation is quite often going on in large markets and strong patent countries, which means usually the UK, Germany, and then one or two other countries from the Netherlands, Spain, France, maybe Italy. And then on the basis of the outcome of those cases, the case gets settled for the rest of Europe. And that, I think, will continue to be the case, except that now it is more likely that the choice will be made to litigate before the UPC, because then you have 19 countries at once. Add to this the UK, and then you settle for the rest of it. That would actually be my prediction. But I don't see a trend to limit necessarily to one forum, as was just said, because I think that is very much in the framework of SEP cases, where you can see whether there is a global interest, of course, in license setting. But in pharma cases, we very much still see much parallel litigation going on. And you can see this, for instance, from the Pixibon case that really went all over Europe. Now, to finish off on a few of the advantages, so why would you go to the UPC rather than to a national court? First of all, it's cheaper if you choose more than 2 countries, and you have 18 countries at the same time. The downside of this, of course, is that you also have the risk of invalidity in 18 at the same time. So this is not the form for weak patents. But if you have a strong patent, this is certainly the place to go. Now, as to the rules of procedure, we have tried to set up the best of both worlds, combining civil law aspects with common law, which is, thank you to the UK, they were originally to participate in this project. So we took along common law principles as well. So now we have a very front-loaded written phase combined with a hearing where we allow experts and witnesses to be heard and, if necessary, also cross-examined. Not like in the High Court cases, like for 3 weeks, but at least some hearing will be possible. The court will be cost-efficient and also quick. It's envisaged that decisions will be ready for within a year or so. And in relation to non-practicing entities, it's quite important, I think, other than in the US, we have a system of cost shifting. So the unsuccessful party has to bear the cost of the successful party. And in addition to this, the defendant may request that the claimant provides a security for cost of the proceedings. So that certainly prevents reckless proceedings by non-practicing entities. Now, as to this security of cost, I'm not sure where we are with the slides anyway. Yeah, there we go. We said it's discretionary power of the court. The criterion is there is a reason to order security if the financial position of the claimant gives rise to a legitimate concern that the costs will not be recoverable or it cannot be enforced. And the burden of substantiation of proof is on the defendant, but if the defendant has all the public available information on the table, and on the basis of this information there's a real concern that there is no sufficient fund of this company to be reimbursed for any costs, then it will fall upon the claimant to challenge the facts and also to provide additional information to show that it does have sufficient funds. Therefore, because that's the information that is actually only within the claimant's control. And normally, the assets of such a company, a non-practicing entity as we know it in the US, is usually only the patent portfolio. And that, the Court of Appeal has just said, is not sufficient because, I mean, that's the whole thing. If the patent is invoked or if there's no infringement, then of course that will lower the value of the portfolio to almost zero, and that will then not be sufficient security. Then finally, there may be a defense it's quite often run and said, well, if we have to put up security for a cost decision in advance, that may basically interfere with our right to an effective remedy and to go to court. But that was denied because the court said, well, sufficient financial funding, not just for you to start litigating, but also to cover, if necessary, a cost decision is an appropriate financial funding of your business model, and therefore the obligation to provide the security for cost cannot be considered to be an additional burden that hinders access to justice. So that's, I think, a reason why NPs have not come to our court as much as was feared by some. Well, I think it's actually one of the advantages of our court to provide this sort of reasonable balance between the two. As other advantages of our court, I would only like to mention that in all local divisions, the use of English is possible. We are setting up a patent mediation and arbitration center alongside the court. It can be used in cases that are appropriate for such dispute resolution. And finally, we do have the possibility for video hearings, but I must say, as a general principle, cases under substance are heard on site. And although during the pandemic it has proven very useful to have video hearings, my personal preference, and alongside my preference, also the preference of many judges in our court, is that substantive hearings are heard on site. And I'd like to leave it at this.
네, 감사합니다. 칼덴 판사님. 칼덴 판사님.
Thank you very much on this presentation. Maybe Mr. Rader and Judge Cheney, I do have a common question to two of you. First, had the establishment of the UPC any impact on the forum or procedure of litigation in your country, or have there been any discussion on them? First, Judge Cheney, you have 3 minutes to answer this question.
That's a big question for 3 minutes. I am so honored to be here, and I am so honored to have been joined this morning by the justices of the High Court of Korea, honored to be with the justices and judges of the IP court here in Korea, and with these really distinguished judges on this panel. judges that I've learned so much from throughout the years. I am here on official travel from the United States government because our government understands the importance of the relationship between our two countries. And even though the things that I will say today are my own thoughts, I wish to convey the thoughts of the commission that I work for about the importance of the relationship between our countries and between our industries. The question that was posed was about the effect of the UPC on selecting forums in our country. And so far, we haven't seen a great deal of effect. But when I go and speak to lawyers at conferences like this, they always come up to me afterward and they say, have you heard about the UPC? Do you know how fast they move? Do you know how big the market is that they can affect? And those two things are advantages that the ITC that I work for in the United States has always been known for. We've been known for speed and for controlling the access to a very large market. The market in the United States is about 330 million people, but the UPC now has the ability to issue an injunction against 300 million people in 18 countries in the UK. So it now brings some economic parity. But we'll have time to discuss these things more. I can only give 3 minutes of introduction, but I do want to say a couple of things about litigation with Korean companies at the International Trade Commission. Here where I work at the International Trade Commission, we have many investigations that are brought by Korean companies. We saw Judge Lee give a presentation about different litigation brought by Korean companies in the United States. And it's very important to us. We have many American citizens who are employed at manufacturing plants in the United States that are run by Samsung and Hyundai and Kia and LG, and these jobs are really important to our economy, and the ability to resolve disputes in a forum that is beneficial to both of our countries is very important, and I hope that we can continue to provide that even though we have some good competition from the UPC.
네, 감사합니다.
Thank you. And I would like to ask Mr. Rader to give your answer, please.
Sure. Technology knows no boundaries.
Please turn on the microphone.
Technology knows no boundaries. That means that with a major patent or innovation, you can sue anywhere in the world. The key to international patent strategy is leverage. You want to go to the place that will give you the earliest, strongest leverage over the infringer. Now, that means that the UPC is a very influential court, and it is taking cases away from the United States because you can sue and get fast leverage from a UPC judgment. Now there's a key. You always want to file simultaneously in the US. You do not want to settle your international case in Europe. You settle your case in the US under its favorable damages law. You get better compensation when you settle the case finally in the US. But you want to obtain that settlement based on swift leverage you get more often from Asia or from the UPC. And Korea has done something very smart. They have allowed English in their Korean patent court. That means you maybe can get early leverage by coming to Korea as well. But you'll always settle in the U.S. And by the way, that is the key to Judge Cheney's court, too. He gives you leverage over the entire U.S. market faster and cheaper than you can get. So you go to his court or the UPC or Korea and then settle in the U.S. Thank you.
다음으로 두 번째
Next, we will move the second question. And first, a question to Judge Cheney. Based on your experience with ITC, MP lawsuit in the U.S. and about forum shopping, could you maybe give us presentation? You have 9 minutes for your presentation.
Thank you. This is my first 24 hours in Korea ever. And you really know how to make a good first impression. My hotel room has this beautiful view over the Han River. And when I woke up this morning, the sun was rising over the Han River and everything was on fire with the light and the autumn colors. And it's just such a pleasure to be here. So maybe I can provide some leverage at the ITC, but I don't know that I can match the view over the Han River in the morning. The ITC has some unique features that help mitigate against NPE litigation that are built into our system. To obtain a decision at the ITC that is favorable, you have to show that you have a domestic industry in the United States. And that domestic industry standard means that you're practicing the technology in the patent and that you're making significant investments in the United States economy related to that technology. We use that phrase domestic industry, but it doesn't mean that the company that has a domestic industry needs to be headquartered in the United States. It does not. It just means that the company is expending resources that contribute to the United States economy. And that could happen in a number of ways. You could have research and development happening in Silicon Valley with engineers employed by the company. You could have a manufacturing plant in Georgia making batteries for electronic vehicles. You could have a facility where you do research on strains of botulism for Botox. All of those things can constitute a domestic industry. And so when we have a domestic industry in the United States, that's one of the elements for getting relief at the ITC. Some of you may not be familiar with the differences between the ITC and the U.S. District Courts, and I'd like to review some of those differences. As Judge Rader mentioned, the main remedy that we provide at the ITC is access to the U.S. market. If a product coming into the United States is found to be infringing a U.S. patent and that product is practiced by a domestic industry, then the ITC can issue an order that goes to each port of entry of the United States. And we have about 180 different ports of entry around the country. And that order keeps products from coming into the United States that may infringe the patent. We don't have power at the ITC to award money damages. So that's not something we do. And we don't have juries, which you might be familiar with in the U.S. District Court patent system. So those are some of the distinguishing features. Also, we have some deep expertise at the International Trade Commission. Currently, we have 6 judges, and 5 of those 6 judges have engineering degrees. All of the judges have 2 attorney advisors with engineering degrees. And so every time you have a case at the ITC, you're getting a trier of fact that has deep technical expertise available to them. About 90% of the cases we do at the ITC are patent cases, and we're having an increasing number of trade secret cases. When I started practicing at the ITC maybe 15 years ago, we had 1 trade secret case every other year. In 2022, we had 14 trade secret cases. So we're seeing a big uptick in trade secret enforcement at the ITC. And some of the reasons that we see more trade secret enforcement is because of the speed at which we can do it. At the ITC, you go to trial in about 9 months. Your trial will be in front of one of those judges that has expertise in technology. That judge will issue a decision in about 3 months. So at 12 months after filing the complaint, you'll have a decision from a judge. That decision is then reviewed by our commission. We have a bipartisan commission. It's not political. We have 3 members from each party, and that's intentional to make our tribunal neutral in terms of politics and more focused on data and economics, not on politics. Those commissioners all have attorneys that advise them that have engineering degrees. So by the time you get out of a final decision out of the ITC, about 16 different people with engineering degrees have taken a very close look at your case. And what this means is that the decisions that come out of the ITC tend not to be overturned. We have a very high affirmance rate at the Court of Appeals for the Federal Circuit. I will brag just this much and say that it is the highest affirmance rate of any tribunal that is reviewed by the Federal Circuit. That means that you can count on your decision. In fact, the judge's decision is very...
Because your opinions are so long, we don't want to read them.
They are very long. Our opinions tend to be about 300 pages long at the judge's level. So every single issue that you bring to us, we will write about it. That's very different from a district court, which gives the decision to a jury, and the jury does whatever they're going to do in a secret room and gives you a yes or no answer at the end. Any part of our decision can be reviewed and examined, and I think that's what makes it valuable in other forums around the world. You might not know that the ITC's decisions have no preclusive effect in district courts. A district court does not have to follow an ITC decision, but it's actually very rare that it departs from it because the ITC decision is very thorough.
And you go first.
And we tend to get across the finish line first. It takes about 3 years to get to trial in a district court in the United States. So we're all done with our trial around 9 months, with the judge's decision at about 12 months. The ITC also, between the judge's decision and the commission's decision, the judges are rarely overturned. So whether there's an exclusion order or not an exclusion order, which is the big picture issue, that is, once you get that decision, you can count that more likely than not it will carry through all the appellate process. And that allows parties to order their affairs in a sensible way. It also drives settlement, as Judge Rader was talking about. once an ITC exclusion order is in effect, it really has such dramatic economic impact by closing the largest economy in the world to the infringing product, then that really drives settlement rather quickly. So those are some of the considerations that people think about when deciding to litigate at the United States International Trade Commission.
네, 감사합니다.
Thank you. With regard to the earlier presentation, I have a question to Ms. Kalden. So there are, NPEs that are litigated in the UPC. How many cases are there? And is UPC a favored court for NPEs? And as for these questions, please answer in like 3 minutes. Thank you.
Well, we don't keep statistics in terms of is this party a non-practicing entity or not. And I also should add, NPEs are generally looked at from quite a negative perspective, but I think you have to also distinguish between companies that actually sell their patents that they don't use anymore as a means of monetizing their patents in order to then subsequently fund new research. And those are not necessarily non-practicing entities in the strictest sense. So we have some very good examples in Europe, such as Ericsson, Nokia, who very much used to be in the mobile industry in the past. And they have switched their attention and they're now selling the mobile phone portfolios in order to be more focused on networks. And that allows them to invest in that area. That doesn't make them non-practicing entities per se. So where do you draw the line? I mean, you also have universities. They may apply for a patent, get one, sell it, and subsequently use the funds to have some further research done in another field. So I'm a bit hesitant in saying, well, this is a non-practicing entities and we should look at this very carefully. I think we should really only look at the ones that use this as a business model. They're very sort of low financed. There is this sort of companies behind them that have very minimal funds given to the company to only be able to litigate. And if you lose your case, well, bad luck for you. You spend all your time in court. You're stuck with your cost of proceedings. And in this perspective, there is a tendency to settle at an early stage. Well, as said, that doesn't happen that much in the UPC because we have this security of cost and cost shifting. And we now have this decision from the Court of Appeal saying, well, if the publicly available information is on the table and it doesn't show enough resources, then either they have to come up with, these are my assets, or they have to provide security for costs. Yes, I think we are in a more favorable position than, for instance, in the US, where you don't have the cost shifting, and they can basically, just take the risk at very low finance and force them into a settlement. So I see the time is up, but I hope this answers your question.
네, 감사합니다. 네.
Thank you very much. Next, to Judge Rader, we heard about the benefits ITC from Judge Cheney. So explain factors that company consider when they choose a court of litigation between ITC and U.S. District Court. Under which circumstance do the companies prefer litigation in the ITC? So please, you have 3 minutes.
The choice of where you litigate depends upon, well, 3 major factors. First is the time it will take. The second is the expense that you will have to put out. And the third, again, is the standing of that litigation with respect to the entire international market. In that sense, when I'm advising clients, I very often say the ITC is the best place to start. We will finish in a year, not 3 or 4 years. We will expend far less. It's interesting, you have to spend that money faster, so it's expensive up front. But over a 4-year period, you will do a better job of conserving your expenses at the ITC. And if you can shut off access to the entire market, you have all the leverage you need for your international litigation wherever it's occurring. Again, you always file in the district court too, because once you've got the leverage, you want to settle using U.S. damages law. So you'll settle in the district court after winning the case at the ITC. Thank you.
레이더 변호사는
Well, now you have been the head of the FTC and also worked as an attorney, so you will talk he will talk MP litigation forms of opinion. Again, 9 minutes, please.
Let me tell you an experience. Shortly after I left the bench, I was invited to a very important corporate board meeting, and the general counsel introduced me with great fanfare saying, Judge Rader will help us decide which court we should use on our important patent case. Now, he wanted to make it dramatic, so he said, how many think it will be Texas? How many think it will be Delaware? Sorry, Delaware was second, Judge Jordan. And third was California. Well, when I rose to speak, I said, it's very interesting vote that you just took, but my answer is, you should go to Dusseldorf. Now, that was before we had the UPC. I might today tell them, go to the UPC or go to maybe the Korean Patent Court, where you can still get a hearing in English. The key there is that, again, you're looking for swift leverage in an international marketplace. You can do that very effectively in the UPC, where you are likely to get a judgment inside a year. The same at Judge Cheney's court. The expense will be less, and that will give you what you need then to come back to Texas or Delaware. We'll go to Delaware, Judge Jordan, and settle using U.S. damages principles. I often teach my students in my patent law courses that this is one area where choice of court and even choice of judge really matters. By the way, that's a little strange as well here in Korea. You don't think of choosing a judge, but that becomes an important part of your strategy in the United States. You want to get before Judge Albright. You want to get before Judge Gilstrap. You want to get before Judge Jordan. And there are ways that you can choose your forum and even your judge, although that's becoming more difficult with some rules changes. But in summary, the key to international litigation is obtaining that early leverage and then using it in settlement. And NPEs, one quick point on that. You heard that 60% of the cases in the U.S. district court system are brought by non-practicing entities. There's kind of a reason for that. Most of the big competitive litigation between two equally matched competitors, most of that goes to arbitration. Why? You can pick your judges, you can pick your law, you can give a time limit. We want the judgment in 9 months, 18 months. There are just a lot of advantages to arbitration, which means that a lot of that litigation between equally matched competitors is handled in an arbitration setting rather than the district courts, and it makes it look like the majority of the litigation happening is NPE litigation. It's not. It's just that that big litigation, particularly in the biopharma sector, is happening in the arbitration forum. Thank you.
Well, thank you very much. Now, on this, let me ask this question to Judge Kalden. Is there a possibility that the UPC cause forum shopping within Europe? If so, what would be the reason? Could you answer this? 3 minutes. Thank you.
Well, yes, because there is no jurisdiction for the Unified Patent Court outside its own territory. So therefore, forum shopping is limited to within the European, Unified Patent Court. And we do see that there is a certain preference for some local divisions within our court. There's quite a bit of litigation going on in Germany, but I think that can also be explained because Germany used to be a very strong litigation country. Most of the patent litigation in Europe went on in Germany. That continues to be the case now before the local divisions. It remains to be seen how that will work out in the future, because of course they will get very busy and loaded, and therefore it may be more attractive to go to other courts as well instead. For the rest of Europe, it's more like, as I just said, that since they're all based on European patents and the substantive law is very much harmonized within the EPC countries, there is this practice of litigating in some countries and then settle for the rest of it, and that remains, in my view, also under the present system, and I don't think the UPC as such will change that very much.
네, 감사합니다. 네.
Thank you so much. We'll move on to asking this question to Judge Cheney. The ITC is preferred by companies targeting a big market like the US. So I do believe Korean companies will prefer ITC. It is known for delivering judgment within a year and saving litigants time and cost, as you explained. But could you also explain any procedures, practice that enable this shift ruling process? Any tips to Korean companies? So 3 minutes, please.
There are three things I'd like to talk about that allow the ITC to resolve cases quickly. The first is meaningful deadlines. And what that means is that once we set your trial date, we're not going to move it. We're going to keep your trial date. And other deadlines in the case. We set the date that the judge is going to issue the order. We set the date that the commission is going to have their decision. So meaningful deadlines are an important part of speed. And they also allow companies to organize their litigation budgets and to plan their affairs in terms of settlement and other things. The second point that I'd like to talk about is waiver. That's what actually makes these deadlines even more meaningful. When we set a deadline to tell your contentions for infringement or to identify the prior art, we really mean it, and if you don't do it by that date, you've given up the argument, you've waived it. So that's a really important part of the way that we can achieve speed. And the third thing that we do is what I would just call active judicial involvement. All of the judges at the ITC are involved in their cases in live, or not live, but generally video teleconferences about once a month with the parties in the case. And because we're going to trial in 9 months, that doesn't go on very long before we're at trial. But those teleconferences really help to keep the case moving and to resolve disputes. And all of these things together result in what I call the phenomenon that speed begats speed. Speed leads to speed. And what I mean by that is once you have the idea that your case is going to move fast, you stop fighting about a lot of things because there's just no time to fight about them. And that helps the case move even faster. So it's kind of a cyclical effect. Those are some of the things we do at the ITC to help keep the case moving along.
네,
Well, thank you very much. Now, that concludes all the questions, but I do have some additional questions. First to Judge Kalden, the strength of UPC. Companies seem to be concerned that a loss in litigation UPC could lead to patent invalidation across Europe. So many hesitate to bring a lawsuit to UPC. So I would like to hear your thoughts on this.
Well, yes, it's true. It's certainly true. So the positive side of the UPC is you will get one judgment that is enforceable in 18 countries. The other side of the coin is if you are met by an invalidity action, you may lose your patent in 18 countries at the same time. Now, you have to choose your chances. And we see that in some areas, especially pharma, they don't like all their eggs in one basket. So they are primarily opting out their patents. There is a bit of a strategy behind this. They want to first observe how the UPC is working, what the judges are doing. And they may have some divisionals in our court, and then they sort of keep the main patent in the national system and have the divisional in the UPC and see what happens. And of course, if you have not such a strong patent, maybe one on a dosage regime or something, it's probably better not to have that in the UPC. Yeah, so it very much depends on this. If they don't choose the UPC, they're stuck with parallel litigation, which of course also has its pros and cons. Yeah, in the end, they have to see where the balance is going.
네, 감사합니다.
Thank you so much. Next, to Judge Cheney, I have this question. Looking at the number of US IP lawsuits in 2023, it appears that these concentration of IP cases in specific courts have been somewhat eased, with the number of litigation increasing not only in the Western and Eastern District of Texas, but also in Delaware and California. So, what do you think are the reasons for this change?
That's a good question. I want to follow up on something that the question posed to Judge Kalden. It seems to me that if your patent is invalid, that your reasons for not wanting to assert it are that's the sunk cost fallacy. You don't want to assert it because you don't want to find out it's invalid, but if it's invalid, you can't assert it anyway. So you might as well assert it and see what happens. But in terms of the distribution of cases around various forums in the United States, in 2017, our Supreme Court decided a case called TC Heartland, and it changed the standard that district courts look at to determine if venue is proper for a particular lawsuit. So that was a big change that helped distribute cases differently in the United States. And then we had another change that one of the chief judges in Texas decided that instead of having patent cases go to a particular judge, that they would be assigned to various judges in that district on a rotating basis. And that took some pressure off of intensity to file and obtain a specific judge in Texas. So it seems that our Supreme Court is concerned about judge shopping and forum shopping in the United States, and that some measures have been taken to deal with that. At the ITC, we have a law that specifies how cases will be assigned. It says that the cases will be assigned to judges in rotation as far as is practicable, so that helps prevent forum shopping. There was a time at the ITC when we had a judge that was famous for finding every single patent that came in front of him to be invalid. And because we assigned cases on this rotating basis, when this judge was the next one in the rotation, all of the couriers would stand in front of the building with their complaints. The couriers that were working for law firms that were in the know. And then some uninitiated law firm would come and file their complaint, and they would get this judge, and then all the other couriers would quickly try to get the next 5 judges before that judge was up again. So we instituted almost all of our investigations in a matter of an hour at various times. We don't have that system at all anymore. We don't have judges that are known for that kind of behavior anymore. In fact, the ITC is very transparent about statistics about winners and losers. They're all published on our website, so you can see what happens. We also have software or web-based services in the United States where you can look at a judge's record and see if they're in harmony with averages, and so those things are helpful when making litigation decisions.
Well, thank you very much. Now we will go to later which courts in the U.S. tend to favor patent holders and what might be the reason behind this preference. So conversely, are there courts preferred by opposing parties and why?
Well, this would be a somewhat controversial topic, but I think there's a general sense that the thing you look at to determine the benefit of going to a particular judge is their summary judgment rate. How often do they dispose of a case before going to trial? That becomes very important for a defendant who wants to hopefully invalidate the patent or avoid infringement before having to bear the expense of trial. Again, there are lots of statistics on this that you can follow. The lowest courts for summary judgment rate are in Texas. The Texas judges just believe you should have a trial. They do not grant summary judgment kind of as a matter of Southern gentlemanly principle, I guess. The highest summary judgment rates tend to be in California, where the Northern, Central, and Southern District have generally quite high summary judgment rates, terminating the trial before you, terminating the case before you get to trial. So based on those summary judgment rates, Texas tends to be favored by plaintiffs, California by defendants.
그리고 이혜진 판사님께 질문.
Now I have a question.
기업들이 유리한 재판지를 찾아서
Companies may strategically select favorable courts based on time and cost consideration. Could you elaborate on why you think a new court with unified jurisdiction? Well, yes. Companies trying to find favorable formula, of course, is necessary in terms of cost or time. UPC, ITC, or California, Texas district courts. How many company can seek them out? I think MPEs, or if you have a large company with your own legal team, you can do that. But if you have startups or small SMEs, if you have international patent litigation, it could even impact the survival of your business. So IP is becoming global, but each jurisdiction have different rules and procedures. So you might be from. So you have the also issue of the entry barriers. IP issue happens in multiple locations around the world. Hence, it becomes burdensome in terms of cost and time for parties involved. But what if you have neutral and predictable judgment available? I think you can then dedicate your time and cost more on R&D rather than fighting in court. And that's why I think unified jurisdiction and court would be possible and needed. It is already there for US and Europe, but what about Asia? I think you could also have another UPC for Asian market. Thank you. Well, that concludes all the discussions that we had. But from the floor, if you have any questions, we'll be more than happy to entertain them. So if you have a question, please state your name and where you belong to and to whom you're asking the question to. So if there's any questions, please. Now, if you have raised their hands, so maybe Judge Kumbon, you could go first.
I'm Judge Boong-kwon, serving at IP High Court of Korea. Thanks for the insightful presentations of all the distinguished guests and speakers. I really learned a lot and enjoyed a lot at the same time. I want to ask a question to Honorable Judge Cheney on waiver system. I wanted to ask if this waiver system is codified in statutes, and even if so, if I want to ask if you had difficulty to establish it as principle or doctrine. Like, for example, if attorneys might think that in deep down, they might trust judges would give some sort of leniency to that. Did you have that sort of challenge or difficulty? That was my question. Thank you.
It's a great question, and I really enjoy talking and learning from other judges at conferences like this. So at the ITC, we have a law passed by our legislature called the Administrative Procedure Act. And under that act, each judge is given authority to, this is the words of the statute, regulate the course of the proceedings. Pretty general words, but you can do a lot with those words in our system. And maybe about 15 years ago, judges at the ITC started putting out their own individual ground rules to regulate the course of the proceeding in front of that judge. And they started putting in these waiver rules. Those waiver rules have now been affirmed by the Federal Circuit in precedential opinions on a number of occasions. So it's quite well established now in U.S. law that ITC judges can do this. It's also very well established that district court judges like my colleague who is here from Brooklyn can also find waiver for failing to provide a position or information at a certain time designated by the schedule of the case.
Thank you for the answer. And any attorneys in the room who would like to ask a question? Yes, from the same table. Yes. Judge Lee Hyejin and Judge Noteak actually talked about the special court establishment and the special law related to it. So I would like to ask Judge Kalden and former Judge Rader to give us any insight about what we can learn from your experiences.
The Justice No and Judge Lee presented two important things, I believe. First, the International Tribunal, which the Korea court already established a couple of years ago, where the English language can be the formal court language and some other benefit procedurally. However, the case which was brought to the International Tribunal was not so many as we hoped and anticipated. And second important thing was based on the International Tribunal, we talked about, for example, Asia IP Court. The Korean can take some lead to establish the Asia IP Court, which covered the Asia area, like the UPC. So if the Honorable Judge has some advice or view on these two important issues, I'd like to hear from Judge Kalden and Judge Rader.
Well, it took Europe, in the end, only 18 of the European Union, about 50 years, so 50 years, to come up with an agreement to set up this court, which tells you how politically difficult this is. And one of the major problems we had from a political point of view was languages. And we didn't have AI for a very long time, even when it was concluded. AI had not been developed as much as it is today. So languages really was an issue, and especially also the costs of translation, interpretation, and so forth that comes with it. Now we are, well, this is my very personal opinion, but now I think we are stuck, if I may use the word, with a multi-language court, which in my view is not the most efficient court it could have been, but this was the sort of the maximum political compromise that was available at the time. And the problem with this is the difficulty of finding judges that are multilingual to deal with the cases, and I think also in Asia, I mean, English is the international language, especially when it comes to technology. So my personal advice would be to go for English as the only language. In Europe at the moment, ever since the UK decided to leave us, unfortunately, English is actually the common language that is nobody's native language, which basically puts everybody at the same level, which I think is great. And the problem, you know, with German, for instance, I mean, how many judges speak German in Europe? You know, there is an end to our resources, and so and also for, as you said, the problem with the lawyers. If you would allow lawyers from different countries to present a case before this court, but you're still stuck with a local language, in the end, it is not really sort of international, is it? Because if you then come to Korea, you would favor the Korean judges. If you would be in Vietnam, you would favor the Vietnam attorneys. So, I mean, if you would allow them to present the case before all of the divisions, I mean, if you would only have English, that would give a similar advantage and similar disadvantage to all of them. So that would be my personal advice when you set up this court.
The question you have to ask is it worth it? You're going to have, as Judge Kalden pointed out, a real difficulty coming to agreements as to how you're going to select the judges from various countries, how the judgments of a Asian IP court would be acknowledged by each of the individual countries. That's going to be a very costly and lengthy process. Is it worth it? I think there are advantages, of course, of a single court that gives you single judgment, but I think you can achieve some of those same objectives by obtaining leverage in one court or another, and then using that to settle the technology disputes worldwide. That really is the way that the system is working, and quite well. So I'm not sure you're going to find it's worth it to make the great effort to get a unified Asian IP court.
Maybe if I may add, mind you, within the European Union, we had quite a elaborated legal framework for the European Union already. So we already have the Brussels regulation for enforcement and recognition. We already have the enforcement directive on the enforcement of IP rights. We already have a very strong, strongly harmonized substantive law for European patents among Europe. And still, the setting up of this one court, you know, was a real effort. So all of that, I think, would still need to be done among the Asian countries that you were referring to, which is, I would say, a hell of a project.
네, 감사합니다.
Thank you. And Judge Cheney, do you have anything to add?
The success of a court that's competing in the international stage depends everything on the remedy that it can provide. And the reason that I think the UPC has such promise is because it provides a remedy in such a substantial market. So that's got to be part of the calculus, is what is the size of the market for this unified court, and will that market size compete on the international stage? As Judge Rader said, the system that we have now seems to be working pretty well. In every case that I have come before me as an ITC judge, I always ask the parties, where else in the world are you litigating? Because by definition, I've got some international litigation happening because it's in my court. And they're almost always doing different things around the country with different strategic goals in mind. So even with a unified court, countries will, or litigants will try to tailor their particular litigation to their company's particular problem. And that problem may be amenable to a unified court, but it might not be. Because every company does something different, and they all have different economic realities that they're dealing with.
Well, thank you so much. I think we have spent all our time up. So maybe we can get closing remarks from our panelists. So I'd like to ask Judge Lee to start with her closing remarks. Well, this is the 10th anniversary of this conference. I'd like to thank all the panelists for joining us, and as well as the audience for joining us for today's event. So from the first conference, I've been attending every conference for the last 10 years. So I could say maybe I'm kind of the protector of the IP High Court of Korea. And I also have a personal dream, more new and creating more new innovative court with the panelists and with everybody on audience. Hopefully you can all join in this effort. That's my dream. Thank you so much.
감사합니다.
Thank you very much. Judge Kalden.
Well, thank you so much. I hope you found this panel as insightful as I found it. As it's always so interesting in international conferences that each time you learn from your colleagues, and that is why it is so worthwhile that these conferences are organized. So I'm very grateful to the IP High Court in Korea to have organized this conference. I very much look forward to the next sessions because, as said, there's always something new, even for those that travel to a lot of conferences and have these discussions. So please continue to organize these conferences, and thank you so much for having me on this one.
네, 감사합니다.
Thank you very much, Judge Cheney.
In my position, I'm not only a jurist, but I'm also a trade person, because we're a trade court. And about 10 years ago, I worked at the U.S. Trade Representative's office. And at that time, the United States had just completed a very important trade agreement with South Korea, which we call in the United States chorus, which is a pun, because chorus is a group of people singing together. And it's also a combination of Korea and U.S. And it's just really wonderful. As I worked on that trade agreement, I read about the economic miracle. And to be here in Korea and to see that what has been accomplished, and to think about the role of IP in making that happen, and thinking about the unique relationship between our two countries is just a great honor for me. And I look forward to continuing our conversations at lunch and throughout the coming days. I thank you very much for allowing me to be here.
네, 감사합니다. 변호사님 부탁드립니다.
I'd like to reflect just a moment on the historical development of our technological courts. In the 80s and 90s, we saw nations such as the United States adopting a court with unique patent expertise. That spread to Korea, Japan, Vietnam, Thailand, Taiwan. That effort spread into China, and of course, there are 2 decades or 3 decades of nations learning from each other to adopt some kind of expertise within courts to handle difficult technology cases. The next 10 to 20 years brought us into a period of cooperation where the courts would work with each other and see each other and try to learn from each other how to better administer these kinds of cases. I've been a little concerned that that's dropped off over the last 5 or 10 years. That's perhaps the emphasis has shifted to the UPC, and there's great interest in seeing how that will influence the development of technology courts. But I would urge us to continue to learn from each other through cooperation and influence. Just judges knowing each other and talking to each other can advance this process. And that, I think, can elevate judicial performance, which began 30, 40 years ago, but now needs to meet the expectations of really implementing a high-quality jurisprudence in the technology area. Thank you. 감사합니다.
네, 감사합니다. 네, 이것으로 1세션
With that, we will conclude the first session. I would like to thank all the panelists for their wonderful discussion and also presentations. Well, thank you very much, and also thank you to our moderator.
곧 마치면서 1세션 참석자들 기념 촬영이
We will have a group photo session with the session's panelists.